Hi, everyone. This is Joe Naylor. I'm founder and CEO of ImageRights International. I want to thank you all very much for taking time out of your busy days to join us. It's a really important topic, and we have an incredible panel here to kind of talk through some of the issues around copyright registration in general. And then also we're going to take a dive into some of the issues that have arisen with the advent of AI generated content. And also we'll take a kind of a deep dive into how you can actually register with the Copyright Office through ImageRights service, and in particular directly from with Adobe's Lightroom product. And so with that, I will first, I want to thank Artist Management Association and Jen Judkins, the managing director, for all your help in supporting us and making this webinar happen. And then I'd like to thank, again, our three panelists, John Tehranian, founding partner of One LLP, who I've had the pleasure of working with for almost 15 years now, both and working with our clients, and also he is our IP attorney as well. He's fantastic. Dana Hursey, a longtime client of ours, and probably #1 evangelist of our Adobe Lightroom Plug-in. And then Erica Chadwick, who I have had the pleasure of meeting recently and have the utmost respect for her. She's principal agent of ETC Creative and a director of the Artist Management Association. And with that, what kind of the flow that I'd like for the webinar today is John will just kind of kick it off with an overview of copyright law and why it's important to register with the Copyright Office. And it's not limited to US either. I'd say over a third of the folks that we register images for at ImageRights are actually outside of the US. So it's a really important issue. Then we'll go into a kind of a live demo of Dana submitting an actual registration from Lightroom. And then I'll turn it over to me to show you what happens on the back end with that. And then we'll kick into the discussion of some of the key benefits for registering with the Copyright Office, and then kind of turn to the monster in the room, if you will, which is AI and how that's impacting pretty much all that we do in our space. So with that, John, why don't you go ahead and kick us off?
Absolutely. Thanks, Joe, so much. It's a pleasure to be here. And as Joe mentioned, I've been working with ImageRights for almost 15 years. And there is perhaps no single greater thing that artists, creators, rights holders of all stripes can do than register their copyrights in order to maximize the type of legal protection they get. In fact, when someone comes to me with a potential case telling me about how someone has infringed their copyrights or used their works without permission, the very first question I ask them is, do you have a registration? And the second question I ask them is, when did you get that registration? Because it is almost outcome determinative as to whether you can actually pursue your claims with any vigor in court, or alternatively, if you don't have a registration, many times, even if the infringement is egregious, there's very little you can do about it. Unfortunately, that's the way the law is set up. So I'm just going to kind of give a very brief overview of copyright and how registration fits into it. So there are a lot of myths about copyright. And as many of you are probably aware, under the current U.S. Copyright Act, which was first passed in 1976, a work gets copyright protection from the moment it is created. In other words, technically, there are no formalities. You don't have to do anything to have copyright protection. But that statement is belied by one of the very critical procedural hurdles that you need to meet in order to both sue for copyright infringement and also get the most important remedies for copyright infringement, and that is the registration requirement. So registration is not required in order to have a copyright, but it is incredibly useful if you ever intend or want to protect against the possibility of infringement or pursue an infringement claim. So let me kind of give the reasons why copyright registration is so important. First of all, registration provides proof of creation. Obviously, when you submit your work for registration to the United States Copyright Office, a record is created from the government as to a date certain by which you obviously had created the work, because you submit a deposit copy of your work to the Copyright Office. This can be important in certain types of litigation or disputes when there's a dispute as to who created the work or when it was created. Secondly, if you register your work within the first 5 years of publication, you get a presumption of validity as to all the facts that are sworn to in the copyright declaration, including the claim that you are in fact the owner of the copyright. This can be incredibly important because it cuts out certain evidentiary proof you might otherwise need to make down the line as to proving ownership. Thirdly, copyright registration is required before you file any lawsuit for infringement. In other words, if you don't have a registration, you literally cannot go to court until you file your registration with the Copyright Office, and the Copyright Office acknowledges your registration and registers your copyrighted work. But finally, and this is by far the most important reason to register, if you don't have a timely registration, you are per se ineligible for the two biggest remedies that the Copyright Act provides against infringers. Those two remedies are, number one, statutory damages, and number two, recovery of your attorney's fees. So let me give an example in terms of a work that is infringed with a registration or a work that is infringed without a registration. Let's say you have a photograph and someone uses the photograph in an advertisement, let's say a print ad, and they did it without permission, and it's a commercial use, and it was obviously unauthorized, so you decide to pursue a litigation claim against that entity, okay? If you do not have a registration, the maximum recovery you can ever get is literally your actual damages. This is typically what the fair market licensing value would have been if they had asked you for permission before the infringement occurred and you had engaged in a hypothetical negotiation where you were willing to allow them to use your photograph. Okay, let's say that's at most a few $1,000s. That also means you cannot get your attorney's fees. You can never get your attorney's fees if you don't have a timely registration. So let's say you're going after that advertiser for using your image in an ad. Well, your maximum claim for damages is a few $1,000s, the amount they would have had to ask and to get permission to use the photo before they used it. But if they say, no, we're not paying, if you try to sue them, you're going to have to hire attorneys. It's going to cost a lot of money to go to federal court and pursue the claim. And at the end of the day, even if you win a jury verdict in your favor and everything goes right, you will get a judgment of a few $1,000s. And your attorney will stick you with a bill of a few $100,000. In other words, there's no point to pursuing that infringement claim because the attorney's fees that you're going to have to incur are rapidly going to exceed any potential recovery you can have. By contrast, let's use that same example, but with a timely registration. With a timely registration, you are eligible to receive your fees. Now, that's up to the discretion of the judge, but many plaintiffs routinely receive their fees when they are prevailing against an infringer, particularly an infringer who refused to acknowledge the infringement and perhaps refused to pay up and force the litigation. That means you're eligible to have hundreds of thousands of dollars of attorney's fees reimbursed to you. Secondly, you're eligible for something called statutory damages. These are the real hammer in copyright law because statutory damages allow you to recover up to $30,000 per act of infringement or up to $150,000 per act of willful infringement against any defendant who uses your copyrighted works without permission or authorization. In other words, your claim for a few $1,000s, now, if it was willful, you have a claim that it's a $150,000 damages claim, plus you're eligible to receive your attorney's fees. This puts you in a much stronger position to be able to vindicate your rights because statutory damages serve a punitive role and a deterrent role. And they also dispense with the evidentiary need you need to have to back up how much your photographs are worth. So registration can make all the difference between giving you an ability to pursue infringement, both online and offline, and having an inability, in the case of non-registration, to actually go after defendants who are infringing your works. One other quick note, I said timely registration, not registration. Why is that important? Because in order to recover statutory damages and attorney's fees against the defendant, you not only have to have a registration, but the registration must have been filed with the Copyright Office before the first act of infringement by the defendant began. What that means is, what I advise all my creative clients to do is register every single work you have that may conceivably have any value in the marketplace or you don't want people infringing. And do it immediately, because you want to timely register before the infringers are out there using your work. There is one little exception to that pre-registration requirement, in other words, registration before the infringement begins, and that is you also have a grace period of 3 months from the date of first publication. So the best practice is always within the first 3 months of publication, register your works. It's cheap, it's easy. ImageRights makes it incredibly accessible to do, and it is absolutely a huge threshold necessity if you want to protect yourself to the maximum under the law.
Yeah, thanks, John. Really appreciate that. It is hugely important. I mean, just empirically at ImageRights, we've recovered at this point over $30 million in recoveries for our clients. And if you look at cases involving unregistered images, which we do pursue, we reach out and try to directly negotiate fees on behalf of our clients in those cases, compared to those cases that have timely registration, which either provides us recourse to escalate to a legal partner, settle it directly, and escalate and litigate. Cases settle an order of magnitude higher as far as the settlement amounts compared to cases do not have registered images. So it really does make a huge impact. So with that, Dana, you're well versed in this and understand the implications of registration and have made that a fundamental part of your workflow, and would love to see what you do and how you go about it on a day-to-day basis.
Sure. I'd be happy to do that. I can just share my screen and kind of walk you through my internal workflow for this. Let's go. So I'm a big Lightroom user. It's really where I live in my day-to-day workflow. And the beautiful thing that I have been advocating for is ImageRights plug-in, which it serves multiple purposes, but the big one that we're talking about today, obviously, is the copyright registration process. And with the plug-in, what I'm able to do is really kind of set myself some reminders and automate much of this work. What I've done, it sits in the published services in your Lightroom module. So in the library module, when you install the plugin, it populates under the published services. And what I have done over the years now that I've been using this is I basically create folders of batches of images. The first thing that I do is I've got a smart folder inside the published service, and all this smart folder does is it populates the folder with images that are created after a certain date. This is the rule I set up, that the capture date is after a particular date. And it also, all of my images start with my initials. That's just my naming paradigm. And so those are the two specifications that I have. So any image I've created that's been created after a certain date pops into this folder. And what it is I just update this each time I do a registration with a new date. So consequently, what I get is a folder full of images that I need to register. It's basically my reminder. I don't have to think about it. All of my images get ingested into Lightroom, and anything that's populated or actually created after that date I set is something that I haven't copyrighted yet. And so I'll actually walk through the process here. I'm going to just do a very small amount to kind of expedite things. I'll just do a few images here. But so let's say that this folder was populated with these 6 images. All I have to do is come in, select those images, and create a new folder inside of my published services with Lightroom. So I just create an image set. I include the selected photos. I give the image set a name. And normally what I do is I name each of my registrations with the job numbers. So it might be a series of job numbers or just a single job, depending on how many images. Currently, the Copyright Office maxes us out at 750 images per submission. It used to be unlimited, but those were the good old days. Now we're just limited to 750. So that's the other thing I watch for, is sometimes I have to split my registration into multiple pieces to keep under that limit. But normally this would be a job, my job numbers that I would use for the name of the set. But here for this example, I'll just say Food and Finley. And I will hit create. And what that does, you'll see over here at the bottom, it's dropped it all the way down to the bottom. It's the latest entry. This is numerically and alphabetically organized. And so here are these images ready to go on board. And so all I have to do is come down to the bottom, click on the publish button, and you'll see in the upper left-hand corner that it's actually publishing these images to ImageRights. This has got 2 great purposes. One is that it's putting everything up there and it's going to make the registration process really easy for me. The other thing it starts to do is now it's on board with ImageRights, and they can actually pretty much immediately start scanning the web for instances of these images and alert me to any infringements that might be going on. It's done. These live up on ImageRights right now. And so what I can do is, again, from this collection, I can click on the images in that collection, and I come down to the plugins extra, because this publisher is a plugin, and I can click on prepare a US Copyright Office registration for these selected images. So I just select the entire group. I click on that. Dialog box comes up and is basically identifying the pictures on the ImageRights side. And then it's going to actually create and populate a registration form for me. If any of you have done a registration through the Copyright Office directly, it's a little daunting and laborious, and you have to really pay attention to what you're doing. This is the big reason that I advocate for using this process. I've filed in my life 2 registrations through the Copyright Office itself. Everything else I've done through ImageRights, because I don't have to think about it. I don't have to spend hours in front of the computer making sure I've crossed every T and dotted every I. Here's my form. It's ready to go. All it wants is the title of the work. So I'm going to give it the same title, Food and Finley. It's asking what year the images were completed in, because you have to keep all of your registrations within a year's time period. So I'm going to put those were all done this year. All the other information is populated from my ImageRights account. So now there are a few options here. If you need expedited handling, or if you need to put in a different mailing address, you can do all that. But again, everything's kind of populated and I'm ready to go. And my mouse just froze on me, so I'm just going to get that running again. And all I have to do is click on save and continue. I've got 3 options here: a single image, published photographs, and unpublished photographs. And I'll tell you right now, to John's point, my workflow is I try to register everything before it ever gets published. What I do is I try and register everything as groups of unpublished photographs. That way it's all covered and I'm not having to do these multiple registrations between published and unpublished. If I do it immediately after I generate the images, I don't know which images that the client is ultimately going to decide to publish. So currently everything's unpublished. So I can simply click on that It shows me the images. For larger groups of images, you might get a box that says, hey, there's a bunch of images here. If you want to bypass this, you can just bypass it. And I come down to the bottom, click on prepare my case or my registration. And again, it's going to ask me to certify that these are indeed all of my imagery, that I am the author. I click on that and click submit, and I'm done. It's really, I mean, there's just no possibility of doing it that quickly if you're going to the US Copyright Office site and doing it yourself. And my time is worth so much more than the nominal fee that ImageRights charges to do this for me. I can do this in a few minutes. You know, if I'm not talking about it, I could have done this in half the time. And I'm done. And I can basically come back, and then what I do for my own workflow is I come in and I rename my image set, and I just, for my own verification, I just put the word submitted in there. And then I check back with ImageRights occasionally to watch the status of that. And you'll see in my organization here, all of these groups that are registered. So once I see that the registration has taken place, then I change the name to registered just again, so I know, yeah, I've taken care of that group of images. These guys down here are in process. They're all submitted. And even once they've been submitted, you can get through ImageRights, through the plugin, verification that the Copyright Office is in receipt of that registration request. Whether you do this next step during that process or after or both, which is what I do, you can then come into any one of these and select, again, through the plugins manager to download the status. And what that does is it brings in the current status, whether it's in process or whether it's already been registered. And with registered images, once you've done that download of information, if you come over to your metadata panel in Lightroom, so last panel in the library module, metadata, you can scroll down to the bottom, and the plugin and ImageRights gives me all of my information down here. It says it's registered. It gives me the actual registration date, the certificate number, and a case ID. So it populates that as well. And subsequently, I can do searches and metadata searches within Lightroom to find certain things. If I needed to find all of the images that were registered with a certain certificate, or whether something was registered or not, it just brings all that in and streamlines it. So that's basically my workflow. It's something I do. I base it on image quantity. So kind of the minute I hit up against that 750 limit, I'll do it, or I'll at least do it quarterly so that I hit that 3-month mark that John was talking about for the grace period in case something has been published. I don't have to pay attention to that. If I'm doing it every 3 months, I'm hitting that benchmark. So that's my process. I'll, at this point, pass it back off to Joe.
Yeah, Dana, thank you. That really nice to see how you actually use the product here for us. I'm going to share my screen. And what I'd like to show you is what actually happens on the back end once one of our clients submits a copyright registration to us. And so what effectively happens is we take the data that's input, kind of essentially our system logs into the ECO website or the USCO's copyright registration website and creates the application on the site. And so what we do on a daily basis is we'll come in, we'll see what cases have been submitted. And here you can already see that Dana's application is up here. It's been created. We can, and then our process is we come in, we'll review it. We'll see the titles, dates. If this was a group of published images, quite often our clients will put the year that the images were published in the title, and we'll just make sure that that matches with the actual publication year. One of the what's really important is that we have a lot of error checking in the software. We have error checking at the time that we're uploading this information to the Copyright Office. And then we have this third round of review by a human to just make sure everything looks in order. And the reason that's important is because if you listen to the Copyright Office when they're talking about registration, operations, and so forth, one stat that they tend to mention is that they have a correspondence rate of around 40%. And what that means is about 40% of applications for registrations that come in require some type of correspondence between the USCO specialist reviewing the application and the correspondent that's assigned to that. In our case, it's ImageRights. And the impact of that is it greatly drags out how long it takes to get your registration issued. Because of all the checks that we do in the process, trying to ensure that there's not errors, or if there are, they get filtered out and corrected before we actually do the final submission to the Copyright Office. Our correspondent rate, after having registered over 1.3 million images through this platform, is less than 1%. And as a result, we typically get the certificates back in generally about 2 to 3 weeks. And it's really as simple as submitting well-formed, error-free applications for these registrations that results in that outcome. And so here you can see, we can look down and see, okay, yep, this all looks okay. If it's a new client, maybe we're not as comfortable if they know what they're doing as far as what they can register. For example, there's a big difference between registering photographs and 2D artwork or illustrations. You can register up to 750 photographs, but unfortunately for artists and our digital artists we work with, there's a limit of only one published work per registration, or if it's unpublished, they'll let you register 10 in a single registration. So hopefully over time, the Copyright Office will address that kind of inequity. It makes it a lot more difficult, a lot more expensive, obviously, for artists, yet it's still something that's very important that should be done. And so part of the reviews will go back and make sure that the images are indeed photographs. They're not photographs of artwork hanging on a wall in a museum that has to be disclaimed and things of that nature. And so then once we submit it, it's as simple as you add it to the cart, check out, we have a deposit account on file, you pay, you say okay, and we're effectively done right there. I mean, it literally takes me or whoever's reviewing the registration applications 30 seconds if everything looks good to submit. And then what actually happens at this point is that our system will receive the notification back from the Copyright Office that the application's been uploaded, that the ECO filing fee has been paid, and then our system will automatically package the images into a zip file and upload them as the deposit copies, and the list per their requirement, listing out the image file names. And then, so what I'll do is I'll switch back to our interface. And so here I'm logged in. I'm essentially looking at my account as if I'm Dana. I'm on the USCO registration page. I can see registrations I'm still working on. I'm seeing ones that have been paid by ImageRights and acknowledged, which means that deposit copies have been successfully uploaded. Here are ones that have been issued. And then I can go down further and there's an option where if you've already registered on your own, you can always just upload the certificate and we'll associate that certificate number with all the images that you've uploaded to your ImageRights account. And a couple of things to really highlight here is one, once it's been submitted, but it's still pending, if you need the application for something, if you're working with an attorney and they're like, okay, we don't have the certificate yet, but we could really use the application, we have that right there for you. And so this is actually the application that's been submitted through the ECO website. If you already have received the certificate and you need to go get it real quick, you can always just go back to, you got your whole history right here. You can click on one, download it, and boom, there's your certificate. it's right there ready for you to go. So we're effectively kind of a management system for you as well. You know right where to go whenever you need to get one of your certificates. And then something that we do that's unique to my knowledge is ImageRights will also create this warranty document. And I'll just show you, I've already downloaded one here. And what this is, when we're trying to deal with infringers, especially directly, quite often the infringer, they may not be sophisticated or what have you. And they're like, how do I know this image was really covered by this registration that you just sent me? And in the old days, you had to go, oh, you got to go to the copyright office and request the deposit copies. It's like $100 or something, and it takes weeks to get them. So that was just like a complete grind to a halt of trying to get something resolved. And so we created this document. It basically warrants that ImageRights registered these photos, and we showed thumbnails of the photos with the file names and the status and the case number and the date. And so we can send that out and say, look, we're warranting that these were actually covered by this registration. And in 99% of the instances, that gets us through that hoop. Once it's actually been issued, I'll show you another one here. We automatically update the warranty in the system, and now it's been populated with the actual registration number. And so these are just some of the things that we do to facilitate the process of trying to resolve these copyright infringements on your behalf. Okay, with that, so I'll make one more comment. When you're registering through our system like this, obviously we have all the metadata associated with the images in our system, and it really goes to help us when we're analyzing the sightings that we find of your images, because one of the things that we do is we kind of filter and then rank the sightings that we consider the good pursuable ones if they are indeed infringements, and we will rank it according to what our projected value would be for that. And so if we know it's registered, and furthermore, if we know it's registered timely, that's a major factor in increasing the value of that potential claim. And so those are going to be at the top of your inbox when you're going and reviewing, and that allows you to get a better return on your time spent claims, and we can quickly submit them. But we'll limit the conversation to copyright here. So I'm going to go ahead and stop sharing. And, John, back to the kind of general discussion on copyright. So can you elaborate on the key legal benefits and protections that photographers and illustrators, which I think is important for this group, gain by registering their works with the Copyright Office, especially in the context of potential copyright infringement cases? I know you touched on this in your opening, but really drilling down to how it can help them.
Yeah, it can make all the difference between making a case worth pursuing and making a case not worth pursuing. To give an example, in terms of the types of cases I will pursue as a litigator, I will very rarely take on cases that involve unregistered images, unless literally there are hundreds or thousands of them, because then you're looking at small multiples of actual damages actually coming up to a number that is meaningful as far as warranting the expenditure of attorney's fees on a case. By sharp contrast, if you have a timely registered image, every single timely registered image can create liability of up to $150,000 per act of infringement. Some of you out there in the webinar may recall a number of years ago, the recording industry engaged in a litigation campaign against peer-to-peer file users who were swapping MP3s of songs, right? The actual damages for those infringements was $1, because after all, you could get those songs for $1 in iTunes. But the damages that courts awarded in those cases were in the hundreds of thousands of dollars. Why? Because of the availability of statutory damages. If all you could get were actual damages for those infringements, if you infringed 20 songs, you would arguably be only responsible for $20 of actual damages. But with statutory damages, those 20 songs can lead up to $3 million of liability, especially if you can prove that the infringement is willful. So once again, being able to protect your work is, I know, a priority to everyone on this webinar. The single most important thing you can do to give yourself meaningful protection is to register your work. I know how hard artists work on creating the output that they put together, but this small additional step to protect it is oftentimes just as important.
Yeah, I mean, Erica, as an agent, what are the conversations that you have with your artists kind of around copyright registration? And
well, interestingly enough, until we met you, Joe, there weren't a lot of people registering them. And now it's so easy that I have to tell them the horror story that one of my artists is currently in the process of suing a client, a pharmaceutical company that used his images a year beyond their original license date. And this happened probably 2 years ago, but we are still in the process of suing them. So it's been very educational. And I think with Joe's math and the math that our attorney gave us, had these images been registered with the Copyright Office, he would be entitled to about $1.8 million. And we're only looking at right now of $100,000 or somewhere around that, minus 40% for attorney's fees on the award on that. But it's still not settled yet. And it's been an enormous suckage of time for me, the agency, and the photographer. I think this would be settled though right now, had those images been registered. So I just see it as a huge missed opportunity for photographers to ensure, one, their images aren't used, two, to settle things very quickly and effectively, and for a fair price point. It just makes everything so much easier. That's kind of what I got to say about that.
yeah, I mean, Dana, Erica touched on something, and I'll go back when we first started ImageRights and 09, I guess, when we launched the search. AS&P actually had just done a survey of their membership, and like 3% of them were registering their images. And it just blew me away. And they did a workshop tour in different cities, and I went to a couple of those just to kind of see firsthand, what was going on and why these photographers weren't registering. What do you say to your peers or other photographers who are hesitant, or they just say, I don't have time for that? How do you encourage them or kind of motivate them to actually do it?
Yeah, I mean, it's one of these things where before 2011, I didn't register either. I was part of that constituency that was not registering. So nothing before 2011 had I ever registered before. And it was only when it's one of these things, we all start to register right when it's too late, or because it's too late. I started registering because I had a very similar situation to Erica, where a client was using an image outside of their license and they wouldn't stop using it. And it was already too late on that one because, but it's like, no, I need to register these because I anticipated that they might start using them in other places as well, which could have happened. But once I started doing that, and once I kind of climbed on board with ImageRights, I was unaware of how many of my images were being infringed upon. I mean, it's kind of nuts. And these days, when I get a citing come in from ImageRights saying, hey, we found what could be an unlicensed image, I'll say, yeah, it is. And I'll submit it, and it's not timely. The registration for it, they started the infringement in 2008 without me knowing, but I didn't start registering until 2011. And so I'm in that position that John has talked about, where it's like, it's not viable. It's just not viable. And the best thing I can do is just get them to stop using it. But for me, I make it part of my workflow. I choose the path of least resistance, which is using this automated process. And I build the cost of it in. I mean, the cost really in the scheme of things is nothing. But I build that into my jobs. I basically, the client never sees it, but that fee, I just assume that that's part of the cost of doing my job, is to get these images licensed. And quite frankly, I do it certainly for myself, but I also do it for my clients, because I have had imagery where I've given an unlimited, unrestricted license to my client, but then a third party will start to use that image in competition to my client. The client can't really do anything about it because I'm the copyright holder. it's really incumbent upon me. So I almost look at it as a service to my clients as well. And I have pursued infringements where my client was perfectly welcome to be using it, but another third party was not.
Let me just add one other note in the chat. We have Kim Maroon saying register, 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 exclamation point. I think that sums it up. And the example both Erica and Dana gave about the license that expires and there's continuing infringing use is a good one, because it illustrates the difference between what happens when you have a registration and when you don't. If you don't have a registration, the most you can get is the exact value that license shows. So let's say you license 10 photos for $10,000. The best you can do is $10,000. If you have a registration and they infringe, you can do 10 times $150,000, so 1.5 million. Your potential recovery is an order of magnitude higher. And even though you're not always going to get 1.5 million, we don't want to make that promise, but you're going to get a strong multiple of what the actual licensing fee would be. And because they know they have to pay your attorney's fees, they'll settle quickly. Whereas if you don't have a registration, they know they can fight it out and you are going to bleed attorney's fees. And so they have no incentive to settle. So it makes all the difference.
Yeah.
And John, you know this. Sorry, John, you know this better than anyone. It seems like the game that I am playing right now with the other side is just how much of my time can they waste?
Unfortunately, that's absolutely right. But the second they know they're paying for my time, they settle.
Yeah, time to register. It's that financial exposure on their end that compels them to come to the table to actually sit down and have a good faith negotiation and try to get it done. So, so I kind of want to turn to the 800-pound gorilla here, AI. So there are two major areas being tested right now when it comes to copyright infringement. On the front end, the ingestion of copyrighted works as training data for these Gen AI models. And then the output, is the AI generated work, is that in of itself an infringement? Who's liable? Is it the user of the service? Is it the platform itself? So John, can you kind of go over those two areas, what the legal issues are, and then what should we as creators and consumers of content be aware of or concerned about when it comes to this?
Yeah, there are a lot of unknowns. I'm sure everybody's familiar and heard the headlines about the lawsuits involving OpenAI, Stability AI, ChatGPT, Midjourney. All of these AI systems are being sued by content owners, in part for their ingestion of pre-existing content without permission to train their AI models, as Joe noted, kind of the first potential infringement. And then the second potential infringement is in the output they create. At this point, we don't have any real substantive judicial readings on this or rulings on these issues. And so there are arguments to be made both ways. I mean, there's a whole body of people who believe that AI training of content, even when it uses content without authorization, should be deemed fair use because it's trans-purposive, whereas, content creators bristle at this idea, saying their valuable content is effectively training brand new content for very commercial purposes, and they should be properly compensated for these uses. On the other hand, the output, almost certainly some of the output is infringing. After all, if I go into ChatGPT and I tell it to write me a sequel to Star Wars, that is almost undoubtedly infringing Disney's copyright in the Star Wars movies as well as the characters. It's possible that AI can provide content that in fact is not infringing, depending on how transformative the use is. But those are questions that are lingering out there. For users of this content, I think what's happening that's really interesting in the field is a lot of these AI providers are now offering to indemnify users if in fact they use these AI models for creating output in case they are sued. I'm surprised at that, frankly, because the exposure for these companies could be huge. I'm not sure how long those indemnification promises will last. And I would be a bit wary of them. frankly, because although companies like Getty, for example, are expressing great confidence in the fact that their AI model has no infringements in it, I would suggest that when you're dealing with a platform of millions of photographs, many of which were shot many years ago, where rights holders are difficult to track down, it's entirely conceivable many of them, in fact, are not properly permitted, and therefore there may be infringement. So I would urge caution to users of AI. And then lastly, I would say also there's a whole issue as to people using AI to create new works, particularly based on their own pre-existing body of works. That's something that photographers are wrestling with, and the Copyright Office is also wrestling with whether those are in fact registrable as copyrightable works, or if they are merely the work of a machine, akin to the work of an animal, for example, which is not copyrightable. You guys will remember that famous monkey selfie a few years ago, where the Copyright Office ultimately denied the monkey Naruto the registration rights to his selfie because the Copyright Act does not recognize non-human creation, and that principle applies equally well to machine creation as well as animals that are not human. So there are a lot of issues. It's going to be an exciting time, and frankly, there are probably more questions than answers at this point.
Yeah, I mean, you tapped into one of the things that I've really been struggling with, and it's the whole issue of, well, let me put it this way. Every few years there's some new technological advance or product or service that comes out that, photographers and artists are told, you got to adapt or you're going to die. Whether it's digital photography or using Photoshop or whatever the case may be. I think what's fundamentally different here in the adapt or die message is the fact that if you adapt, okay, and now you're using AI to generate your content, the fundamental difference now is you don't actually have copyright ownership in that work. So what's the impact of that on the marketplace and on you as a creator? Can you really take the risk and go that route if you can't even protect yourself if you're infringed? So Dana, I'm curious, as a creator that's facing these same issues, how is that impacting your decision on using AI tools, how you would use them, just in general? What's your approach, given that you can't actually at this point have ownership, or at least just from straight up use of these generators, you can always add certain elements to it, but with that comes uncertainty. So
right, yeah, and that's really the big thing right now, is the uncertainty. I mean, we talked a little bit about it previously, and it just feels like the Wild West out there, and it feels like people are making up rulings of their own as to what's copyrightable, what's not, what's licensable. For me, it's a tool. I feel I need to know how to use it, and not just on the surface level, but really understand how to generate stuff with it, and I do. But I don't, at this point, I don't feel I, with any integrity, can turn to a client and license them or say that, here, you've got the right to use this, because I don't feel I've got the ability to do that. Because until we get some kind of ruling somewhere, and I can actually register it as my copyright, I don't have the ability to say that with any integrity, that here, client, you can use this for a commercial purpose. These days, I'm using it a lot I use it for treatments and for decks, and I'll use it for, creative direction. Here's something that we can produce photographically, but here's a way that I can show you what I'm thinking in a more detailed sense, that maybe doesn't exist out there as just pulling scrap from someplace. So, I am not one of those people that's running around with my hair on fire, saying that this is the end of everything, because it's not. We're still going to need to generate original content. AI currently, in its current state, is not able to spit out exactly what's in my head, and yet I'll be able to produce that in a photographic image. I try as I may, there's many things that I cannot get AI to do, and I have a specific vision in mind. So, you know, my clients are still going to want something very specific, which AI currently can't generate. So it's one more time, we say this over and over again. It's a tool. It's a tool in our toolbox. I look at it as such, and it's not the end of the world.
Yeah. Hey, Erica, are your photographers or your clients for that matter, are they asking what they can do, or you know,
It's
in this
kind of
area?
a two-tail thing. Most of the large agencies actually have in their purchase order terms that you are prohibited from using AI at all, because they do not want the legal liability right now. And their lawyers know that if they're using AI, they're probably infringing copyright, and they don't want to do that. There is one large group of ad agencies who has actually signed a deal with NVIDIA to create AI. I'm not sure if that media is infringing copyright or is not. I've not had time to dig into that. I also have a photographer who knows in his neighborhood, the marketing head of like a large financial institution, who is making video with AI. And he sort of brought up to him, do you know that this is probably infringing people's copyright? And the marketing head was completely surprised to hear this. So there are clients that are just not very educated about this at all. And there are clients that are very educated and are steering themselves away from it because they want to do the right thing. So it's really, there's a mixed bag out there.
Yeah. So Jen, I see you have arrived. Do we have some questions from the audience?
So many questions, which some have been answered and some have not. But I'm going to start with Steve's, which is the same question I asked you the other day, Joe. Is there a plugin for Capture One?
So we're going to have news coming very soon on that front, directly as a result of our conversation the other day. So
Perfect. Perfect. I'm glad I asked.
yeah, we're heading down that path fairly aggressively.
Fantastic. John's answered a couple of these questions for folks, which hopefully gave them the answers that they needed, but if they need more, we can answer. What are the advantages or differences to using ImageRights versus Pixie scan and matching technology, time to process the infringement, research, and payout?
Yeah, so I mean, I don't know all the stats on how quickly they do payouts and turn or resolve cases, but I can speak for what we do. You know, and so what we've done is built a platform from the ground up that the number one goal is to save our clients time and this kind of never-ending fight against copyright infringement. And so we've done that by building AI from the moment you upload your images to the moment we pay you out. There's AI built all throughout the process, you know, identifying which of your images are most likely to be infringed, to analyzing an image and identifying the domains that would likely have your type of content, and then passing that over to our other crawler network that then targets that domain for the benefit of all of our clients, because we search every image on that domain and we match it against every client image. And then things such as, once these sightings come in, analyzing the sightings themselves. Are they pursuable? A whole host of factors, everything from, have we dealt with this company before? What country is it in? How much are your images worth? Are they registered? All these factors go into kind of estimating the value of that potential claim, and that's how we present those to you. And then we make it as easy as can be to review those sightings, submit the claims for assessment, and then we can instantly provide you recommendations on, you know, whether or not we should move forward, and if so, what's the best approach? Should we just go out and try to negotiate something directly with our in-house team, or do we pass it to a legal partner who works in that territory who would be good for this particular case? And then once claims are resolved, money comes in, and you know, generally for most of our clients, you know, well, for all of our clients, we will front any legal fees that are incurred in the process, which really comes into play outside of the U.S. because with our U.S. law firms, typically they're contingency based, but in some countries, mostly UK law derivative countries like Canada and Australia. It's billable, but we will front those costs. And if we don't ultimately settle or collect or win, then we eat that for you. If we do, then we back it out and we split the remainder 50-50 with you. So we take that kind of the stress of the costs that may hit when you're trying to pursue these claims, especially if we find many cases for you. We don't want that cost to be inhibiting you from actually doing something about it. And then once we receive payment on these claims, we turn around and send out distribution payments within 2 months, or not 2 months, 2 weeks. And so we feel we've got a good process, and we've talked about the registration. That's a fundamental piece. I'm not aware of anybody that really does it like that. And the complete package works quite well, both for the clients and frankly for us and our legal partners as well.
Great. Thanks, Joe. Also, I asked you the same question the other day too. Can photographers outside the US register their work with the USCO, or is it just US photographers?
No, absolutely they can. So if they live in a Berne Convention country, which is pretty much all many of the countries, they can register with the US. They're afforded all the same benefits of doing so. And like I mentioned, I think early on, over 30% of the registration of the images that we have registered have been for non-US citizen authors.
Let me add just one important caveat there, which is some foreign authors may hear from lawyers, oh, don't worry about it. You don't need to register because you're a foreign author. And that is technically true. There's a weird exemption under US law that says that foreign authors don't need to register in order to sue for infringement, whereas US authors do. But everybody has to register timely to get statutory damages or fees. So even though you may be exempt as a foreign author from registration just to get into US court, you still have the same burden to show timely registration to get the two best recoveries, which are statutory damages and attorney's fees.
Yep.
Peter says, still not 100% clear on published versus non-published. I'd previously been told if I register as non-published, I later need to re-register as published. So best practice is to register everything as published. How would you advise?
John, you're the attorney.
Yeah, right. Yeah.
I mean, I could answer it, but I'll defer to the attorney.
Yeah. No, I mean, look, you can do unpublished. It's fine. You know, there are certain there may be certain reasons to re-register again as published, but it's generally not necessary. I think the most important thing is picking one method and sticking to it and making sure you do it timely. So if you want to wait, because remember, if you register unpublished, you're actually letting your works out into a publicly available database, namely the Copyright Office. Now, you can't search for it online, but people could make requests and subpoenas to the Copyright Office and get a hold of those records. So there are some reasons people may not want to publish an unpublished work, or rather register an unpublished work, because you're effectively creating a public record of it. But assuming that's not a concern, then go ahead and register the unpublished. If that is a concern, register published, but do it within 90 days and make sure you don't blow that 90-day deadline.
And then, John, also maybe go into what actually defines publication in this context.
Yeah, the word publication is actually very messy under copyright law. It goes against kind of what you might expect publication to mean. So, for example, if you do an exhibit at an art gallery of your photography and it's on January 1st, 2020, that's not a publication. Arguably putting your work, say, on your Instagram account may be a publication. It may not be a publication. There's case law and arguments that go both ways. So frankly, one of the issues you get into when you register publication is what is your publication date? And that can frankly be a messy, messy issue that frankly, most attorneys may not even agree about what the actual date of publication is.
Yeah, one of the questions we just got is, isn't it true if it's on your website, it's considered published? Great for the head shakes. Thank you. Kim,
there's an argument that could be made there, especially if the right-click Save As button is enabled as opposed to disabled. But pure public display of an image without more does not constitute publication under Section 101 of the Copyright Act.
Yeah, and if you read, there's section 1008 of the Copyright Compendium, third edition. It goes into very surprisingly explicit examples of what they consider to be publication and not publication in an online scenario. So I would recommend checking that out. And Jen, I don't know if we have a way to push out links maybe to some of these documents too.
Yeah.
Later afterwards.
Yeah, we can send out an email.
Okay.
There's a question. I had a set of images that I submitted to USCO and they rejected them because they thought parts of it were fake / not a photograph. All was shot in camera. They are now asking me to submit a form to fight this decision and charging me $350 for it. I would love to have some clarification on how best to proceed.
Go ahead, Joe.
Yeah, I mean, I'll say they changed the way they handled that a few years ago. I'd say like the first 10 years or so, we were submitting applications. If there was an issue that they were going to reject, they provided you the opportunity to address that. And then all of a sudden we started getting these, your registration has been rejected, and there was no avenue for to appeal that without having to pay that. I think, is it $350? I knew it was at least $250, and maybe it is $350. And so what's frustrating is very rarely do we have one rejected, but where it does tend to happen is if there are images that were first published before 1989, and you need to provide evidence that it was first published with the copyright notice, which was a requirement then. And so when we used to submit those, they'd say, hey, can you show us examples of where they were first published? And then all of a sudden we started getting these just rejection notices out of hand, and never even had the opportunity. So I have yet to find a way to work with the Copyright Office on this once they have officially rejected it like that, unfortunately.
Yeah, I mean, one idea, maybe just withdraw the application, refile, and make sure that in your new application, you are very clear that all of the image was captured photographically, or you disclaim whatever wasn't part of, if it's photograph. In other words, you amend the complaint, you amend the registration, so you basically reapply. That could be risky though, because the Copyright Office may hold that first application against you. But yeah, unfortunately the safest route is to deal with the appeal and unfortunately pay that $350 fee.
Yeah, because you'd also preserve your effective registration date if they ultimately did issue it. But then again, if you register a new one and provide everything that you think you need to do, you're only paying the USCO filing fee, which is a fraction of the appeal cost. So
yeah, and by the way, a rejected registration is actually sufficient to get you standing in court if you believe that it was an improper rejection. So actually, once you're rejected, you actually have standing to go to court. But the other side is going to really push you hard and say you're trying to enforce rights in something that was rejected, and it. Therefore, if we win, we get our fees, which is risky.
Yeah.
Last question. How do I get the Lightroom plugin, please?
So yeah, when you sign up for an account with ImageRights, you go to that USCO registration page that I showed from Dana's account. And if you scroll down, there's all the info on the Lightroom plugin. You download it and you're off and running.
I was going to say, is Natalia here? Can she drop something in the chat? A link in the chat? I see her there.
Well, if not, Jen, we can just send it out with the follow-up email that has links to some of the Copyright Office docs as well.
Can I ask a question of John too? John, is it true that you can't sue in federal court without a registered copyright of that specific work?
You need a registration or a rejection of the registration.
Okay,
yes.
That makes sense. The rejection.
Unless you're a foreign author and your work is a foreign work, in which case you actually can without a registration.
Okay.
Katie just asked the same question about, is there a Capture One plugin as well? We already answered that, which is there's news on that soon.
It's coming.
It's a coming.
Yeah.
If that's all the questions, Natalia came through, John came through with the link in the chat for folks.
Thank you both.
Appreciate it. One last question, tuned in a bit late. Given the advice to register quickly, are you suggesting that the photographer register their work prior the client usage kicking in?
Yeah, yes.
Yeah, absolutely.
Yes, yes.
That's a yes, Jeff.
If
Just
there's
just register immediately. Just register everything immediately. Just do it.
right, another scenario is if they're behind on their payment. I mean, there are clients who just aren't paying in 6 months. You tell them these are registered with the Copyright Office, they're using those images, you'll get paid.
Yeah, that I've used that as a tool in the past. It's like you are now, I say it super nicely. It's like, hey guys, I'm looking out for you. You're messing with a copyrighted image here. You got to make sure that you pay this timely.
I'm going to make this the last question from Steve. Is it still worth registering old work?
Yeah.
Yes.
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 Because if your work's out there, it's still gonna, proliferate across the web. and
New
somebody's gonna
infringements
steal it.
occur all the time, and if you
Yeah.
register today instead of next year, you're going to be able to pursue those claims. If you don't, you're going to be able to pursue those claims.
And you're just gonna kick yourself when you find new infringements kick up and you're like, oh, I could have registered.
Yeah.
Great. Thanks everybody.
Yeah,
So
thank you all. And again, Jen, thanks for putting this all together. And John, Erica, Dana, thank you so much.
Yeah, thank you, Joe, for having this company. It's been a great tool for everyone.
Well, thank you.
Yeah.
All right, guys.
Thanks, everyone.
Okay.
Bye-bye.
Bye.
Take care.